One common principle of democracy is the separation of powers. This principle, given its most famous expression by Montesquieu, divides power into three types or estates: legislative, which makes laws; executive, which carries laws into effect; and judicial, which decides disputes. According to Montesquieu, the best way to avoid tyranny is to have different institutions holding each of these three estates of power. In Australia, as in the United Kingdom, our system is based upon the principles of Westminster responsible government rather than the separation of powers. This is why the ministry, the cabinet, are effectively the holders of both executive power because they control the public service and legislative power because they have the numbers in the lower house of parliament. Still, in Australia, we do have a tradition of free and independent courts. It is written into the federal constitution that only a court can exercise the judicial power of the Commonwealth. Does this rule exist in the states, or is it just a custom? In this case, New South Wales had a legislative regime for setting fair residential rents. Interpretation of that legislation was taken to the High Court, which gave a judgment heavily favouring landlords and disadvantaging renters. The New South Wales Parliament then passed legislation effectively undoing the rule that the High Court had established. Clyne owned the house which East rented, and when the New South Wales legislation was passed, Clyne challenged the validity of the legislation, arguing that the New South Wales legislation was not only overturning the High Court decision, but was also directing the Fair Rents Board in how to decide disputes. In short, his complaint was that the Parliament was interfering with the exercise of judicial power. The court disagreed and said the Parliament was doing no such thing, but the court went further and said that the Constitution in New South Wales didn't require a separation of powers anyway. Justice of Appeal Sugarman said, "The Constitution of New South Wales is now embodied in the Constitution Act 1902 as amended. The structure and provisions of that Act provide no ground for importing into it a similar principle of separation of powers." It follows that the parliaments in each state can in fact encroach on the use of judicial power unless their constitution specifically prevents it. But it would be very rare for a parliament to do so. This is because our custom is to value a free and independent judiciary.